So welcome to Advantage Learning Bytes at Coffee Conversation, powered by the Emerging India Forum, TEIF, and our technology partner, Prime Infotech Solution. Today is a Women's Day special, and today's topic is understanding intellectual property law. We have with us Srividya, a legal consultant with a passion for copyright law and design law, with a remarkable track record of assisting both companies and entrepreneurs in reviewing contracts and protecting their creative endeavors. Ma'am plays a pivotal role in safeguarding dreams legally. So welcome to this mini coffee, where we invite a subject expert to share about a topic and its nuances.
Thank you.
So, Srividya, my first question will be, what are the different types of intellectual property rights?
So intellectual property rights, Mr. Virani, they are a broad set of rights. They're a group of rights. So under this, for example, you have patents. It's an umbrella term or a group term. Collectively, they're called intellectual property rights. And you also have individual rights. For example, you have patents, you have trademarks, you have trade secrets, you have copyright, you have industrial design rights, you have geographical indications, you have layout designs of integrated circuits, and so on and so forth. Since we have a session is a very short one, I'll just briefly talk about the first three. So first one is the patent, of course. So a patent is granted for a product or a process. It's a legal right which is granted by the government, and for the product or process. And the duration of the patent is 20 years from the date of filing of the application. And there's a particular procedure that will have to be followed when you file the patent. And there's from start to finish that relates to that. Then you have trademarks, for example. Trademarks relate to these would be, things relating to like your brands, your logos, your symbols. It could also include names like famous names. And then you have copyright, which relate and trademark. The reason a trademark application is filed for is that it helps you to distinguish your goods and services from those of another trader, and it helps you in terms of managing the competition. And it also builds trust in the eyes of the customer, so that they know that I'm getting this good or this service from this particular company. So it builds trust in the eyes of the customer. Then comes copyright, of course. Copyright relates to a lot of creative endeavors. It relates to, it could be literary work, it could be dramatic work, it could be musical work, artistic work, and and so on and so forth. And copyright, of course, is something that people would be more familiar with because it's in the news very often. And then you also have design rights. So design here in this case relates to industrial design. We're not just talking of some design which is, privately, I just get something on a notebook or something like that. This is industrial design. This is for the industrial world. So these are the designs relate to new or original words relating to, it covers features, it covers shapes, it covers patterns, ornamentation. And the thing is, all these have to be applied to an article through an industrial process. And the features of the design on that finished article have to appeal to the human eye. These are the requirements as far as the design law is concerned. Then you also have geographical indications. Now, as the term suggests, geographical indications are the two parts. Geography, they originate from a particular geography. For example, Kolhapuri chappals, like you have. So the thing would be the product is manufactured in that particular region, which gives it that edge. So I'm sure there must be chappals that are manufactured or shoes or things that are manufactured elsewhere, but it won't match the quality and the thing of this particular product. And similarly for different products all over the country, because India is a very diverse country and every state produces so much. We're so rich in producing so many different things. So, and as the awareness is increasing, there are also more and more people who are filing geographical indications. But geographical indication, one point here is that this is at the community level. these other intellectual property rights are at both individual and maybe industrial company level, whereas this is for the community level geography. And the last one I'll take up is trade secrets. This is something that's extremely crucial as far as business and company and this thing is concerned. So trade secrets, there is no separate law per se dealing with trade secrets under India, but they're covered under intellectual property rights, intellectual property law, and also under contractual law, and the remedies can be both in terms of contractual law and also under the Indian Penal Code. The point of the trade secret is that here again, just like geographical indication, it should relate to a trade. The information should be confidential. It should be something that gives you an edge over your competitors, and it should be something that if it's divulged or leaked, it will cause you immense harm. So that's the thing. And the most important is you have to keep it a secret before expecting others to keep it a secret. So that is and the duration of the trade secret is that as long as you keep it a secret, it is a secret.
Very good explained. Now, a company or individual has done the IPR protection, but what happens? IPR are infringed. So, what are the implications of IPR infringement, and how are disputes resolved?
So first, let's see what is infringement, right? So infringement would be the unauthorized utilization or the reproduction or the distribution of somebody else's work, right? So for example, when it comes to, you go to the internet, you see something there and you think that, oh, this photograph is nice, I'll use it in my work. This video is nice, I'll just copy the whole thing into my work. I mean, that would be an infringement, right? When you're just taking it like that without the authorization or the consent of the copyright owner. So the owner of the intellectual property has the right to take legal action against the people who are infringing. So now, I mean, different aspects, just like I just spoke, there is patent infringement, there's trademark infringement and copyright and so on. I'll just briefly relate to patent and copyright. So there's no exclusive definition of infringement under the Patents Act, but any breach of the rights that are granted under the Act. There are the Patent Act says it's an exhaustive list of all that is granted under the Act. So if there's any breach of those rights, then that will be treated as an infringement by the law. And you also have remedies relating to this. You have civil remedies and you have criminal remedies. And the remedies, for example, the first this thing will be when it comes to the court. Now we all know that it takes the cases take a long time. So it may take a few months, it may take a few years. So the thing is, what does the person do in the meantime? So then the court awards the person temporary relief or interim relief, which relates in the form of an injunction. For example, you have an interim injunction and you have a permanent injunction. So in an interim injunction, it's the order that the court provides or gives, directs infringer to stop the infringing act. It's an order by the court, and so it has to be abided by. Then you also have a permanent injunction. This comes after the stage of the trial. For example, a permanent injunction to be granted, but for a permanent injunction to be granted, there have to be there are two important points. There should be a valid patent, and there has to be an infringement on the part of the defendant. Then, in addition, there are also damages, for example, that the plaintiff has suffered so much in terms of losses. So the court will award damages. Now, how much of damages, whether the court will provide damage in a case, how much of damages the court will provide, that will be decided on a case-to-case basis. And in exceptional cases, there are also punitive damages, but those are subject to certain conditions in exceptional cases. And
so wonderfully explained. Now we're going international. How do international treaties and agreements impact intellectual property rights? For example, India region.
So that's an interesting question. There's a clear. There actually, on the one hand, there's a clear distinction, but then there are also areas where they converge. For example, all these acts that I was talking to you about, the parts of intellectual property, different types of intellectual property law, they can also be individual in nature. For example, the patent under the Patents Act, if I'm granted a patent, it applies only to the territory of India. Like I said, intellectual property rights are territorial in nature. So if I granted a patent, that patent will be applicable only within the territorial limits of India. So that is at an individual level. Whereas these treaties, there are multiple treaties, right from the TRIPS agreement to the PCT, the Patent Cooperation Treaty, to the Berne Convention. All these treaties, they work at the collective level because there are so many hundreds of countries involved. That is one. The second thing is the laws of the country that provide the protection. They provide local protection, or like I said, the territorial within the country. Whereas these treaties, they provide you international protection. And they cover the rights in these laws. The first set of laws, the rights of the inventor or the creator are protected, whereas under the treaties, the right of multiple users under multiple jurisdictions are protected. But one point here to note is that you will be able to get that protection only if your country is a signatory to that treaty and that other country is the signatory to that treaty. Like, for example, if I have some if I want to protect my copyright, I've written a book and I want the book to be given copyright protection in the US, and I'm going through the Berne Convention, then India has to be a signatory to the Berne Convention, and the US also has to be a signatory to it. Only then will I be given the protection.
That's interesting. My next question will be, how does intellectual property law see AI and blockchain evolving day by day? So how can we protect technologies created in AI and blockchain, and what is the implications of IPR? How is it evolving, adapting to cover new technologies?
Yes. So this again is an interesting question because India is right now it's one of the important hubs as far as artificial intelligence is concerned. Every single day there are new inventions, there are new kinds of things that we get to know about. So AI, when it comes to it's one of the most important technologies right now. And like I said, we can see it all around us. And slowly over a period of time, it's altering the very manner in which we live as more and more of it comes into our lives. So the important question, there's a very important question that comes in here when it comes to artificial intelligence or any other types of emerging technologies, is that when it comes to the intellectual property, who owns the intellectual property? Because all these rights that I have spoken about, each one of them, whether it's patents, trademarks, or whatever, all the different ones under the umbrella of intellectual property right, they will come into existence only if you are the owner of the intellect. Your rights will kick in only once you have the ownership. If you don't own something, I mean, you will not have the rights. For example, even in the physical world, if you own an apartment, you can rent that apartment out. But if you don't own that apartment, it would be difficult for you to do so, right? So it's the same principle. So the question then arises: is it the AI system that is the owner of the intellectual of the work, or is it the human being behind the AI who is the owner of the work? So this is a matter of debate, not just in India but all over the world. That's a debate that is going on. And so under the Patent Act, you have something called, there's one section where you have the definitions. And the definition of a patentee is defined as a person for the time being entered in the register as the grantee or proprietor of the patent. So here you can clearly see the person is a human being. So there is no scope for AI to be a patentee. That is so far. And under the Patents Act, it would be difficult for somebody or something who's not a human being to be granted a patent. That was the story so far. But however, there has been a case in 2020 where the court had granted, the Intellectual Property Appellate Board, which was a specialized tribunal, it has now been dissolved. They had granted a patent to an applicant who had applied for a patent. Now the patent had the duration of the patent, like I said, is 20 years. and 19.5 years had already passed, and there were just a few months left before the patent would expire. So in this particular case, it was granted. That is one case. And then there's also been another instance of a healthcare company whose website mentions that they do have patents in the field of artificial intelligence. So there are some cases. So we can't say it cannot be granted at all, but at the same time, we can't say that it's being granted in every case. So the court will take it up on a case-by-case basis. And this, it's a similar situation even under the Copyright Act, because there's a definition of the term author under the Copyright Act. And it says, in relation to any literary, dramatic, musical, or artistic work, which is computer generated, the person who causes the work to be created, here again, person, is the author. So, and then when it comes to blockchain, blockchain can be utilized as far as digital assets are concerned. It's something, since it's a database and it's also it's connected through the use of cryptography. It can be utilized to strengthen the IP intellectual property system in general, and it can also provide a lot of assistance to IP offices all over the world. It can also help in terms of the enforcement of IP right. So currently we have very good laws in the country as far as each aspect of intellectual property is concerned. However, since technology is constantly evolving, the laws will also have to keep pace with the technology. And if it's necessary, when the circumstances arise, the current laws can either be modified, or if it's necessary, new laws can be passed to bring in to tackle this.
Wonderfully explained. Continue a conversation. How do intellectual property rights intersect with other areas of law such as antitrust and competition law?
Yeah. So antitrust or competition law, antitrust or being the same, they aim to basically maintain competitive marketplace. That's the area in which they function, by preventing certain behavior that could harm that competition. So antitrust basically deals with prohibiting anti-competitive behavior. Then it encourages fair competition, and it also discourages abuse of a company's or an institution's dominant position. So the primary source of competition law in India is the Competition Act 2002, and it's enforced by the Competition Commission of India and the National Company Law Tribunal. There have also been amendments to this act, but this is the main source of the act. Whereas intellectual property right is, like I said, is a legal set of rights that are granted to the owner, and the owner is not going to allow others to use the same rights, at least with regard to that creation or that invention is concerned. So in that sense, intellectual property law, there's a possibility of stifling the competition, which is in contrast to what antitrust or the competition law works. So on the face of it, it would seem as if, they're opposed to each other, or there is a conflict, and there is some conflict, but they can also be, they can also coexist, because at the end of the day, they have a common goal. Whether it's antitrust law, whether it's intellectual property law, they have a common goal in that both of them want, they work for the welfare of the consumer and also for the economic growth of the country. So since the two are connected, for the good health of the Indian economy, it's important that the two coexist. So on the one hand, there should be fair competition, that everybody should be allowed to compete and all compete. The laws have to be same for all the companies. But on the other hand, there should also, inventors and creators should be rewarded for their inventions and create. So it's a balancing act that needs to be.
Yeah, ma'am. Continuing, how can individuals and businesses protect their intellectual property in the digital age, where information is easily shared and copied?
So there are some basic things that they can do. I mean, there is a long list. So the very first thing that anybody, an individual, a company, an institution has to do when it comes to intellectual properties, you have to protect it yourself. That's the very first point. Because first you have to be proactive, and then you can expect protection. It's not the other way around. So That is the first one. You protect your information. Like, for example, there's such simple things. You don't, people say that, oh, it's so expensive. You need to do this, you need to do that. If you go to Microsoft Word, under the page layout, you have the watermark. So when you're sending a document to somebody, all you have to do is, especially if it's a confidential document, you have to let the other person or the other party know that it's a confidential document. And you have to mention the same in the email, because sometimes people, if there's no subject in the email, and it may be a very confidential document, but people may not, they may not pay attention to it. So it's important that you mention that in the email, that this is a confidential document or something relating to confidentiality. That is one. Then second thing, in terms of digital rights management, this is of course another thing of digital rights, that you also have encryption when it comes to software, when it comes to music, or could be some literary stuff that is available on the internet. That is second point. Third point, and a very, very crucial one, is relating to your confidentiality agreements and your non-disclosure agreements. Before you disclose something to your partners, your vendors, your suppliers, anybody that you're sharing outside the organization, of course, anybody that you're sharing that organization with, please have a non-disclosure agreement with them, stating the basics of what is define the confidential information, the confidentiality clauses, how long you expect the information to be confidential, and so on and so forth. And the fourth one is again a simple one: document everything. And I cannot stress this enough. Please document everything. I mean, you need not get into fancy kind of software, even simple things, but document everything, whatever you create, whatever you invent. Please maintain a neat record of everything. And the fifth point is, then you discuss with your advocate. If you're an individual, you can discuss with a lawyer or an advocate. If you're a company or an institution and you have a legal team, please discuss with the legal department whatever your queries are, what is permitted, what is not permitted, and they'll tell you what you can do and what you cannot do. Then companies should also have an IPR policy. Every company should have an IPR policy. And the IPR policy is something, not just have it and put it into a cupboard and keep it there. It's something that the employees should know about, the policy and the practices relating to it. And also think twice before sharing your information. Only those within the company. Now, we have tackled outside the company. Even within the company, everybody within the company need not know everything. So only on a need to know basis, those that need to know the information can be shared with them.
Wonderfully. So, ma'am, we're coming to this end of our conversation. My last question will be, what advice will you give to women professionals in terms of IPR and other things?
Some of it will overlap with this. For example, first thing, and again is awareness. For example, thank you so much that you're conducting this session for the people to get to know the basics or basic understanding of intellectual property. For example, this one is a free session. But even when companies organize these kind of sessions, many people are reluctant to go and attend those. But please attend those sessions, because there is so much of information that you will get to know, and how you can protect, how you can identify your intellectual property, how you can protect it, how you can monetize it. Because unless you know the basic aspects of it, how will you go about doing those things? So one is awareness. And then the other points would also be in terms of within the organization, what you can do and what you cannot do. And also read up, for example, go to websites. There are such, for example, the ipindia.gov.in. That's the official website of the Indian government relating to patents, designs, and trademarks. And the copyright.gov.in, www.copyright.gov.in. That is the official website of the copyright law of India. And in this day and age, when you have so much, like you have websites, you have blogs, you have so much relating to all this, please read up, whether it's in terms of books, whether in terms of, and if you have any questions or queries regarding to anything, you can send me an email. I'll share my email in the chat box, and you can ask your questions.
Wonderful. So thank you, friends. It was a wonderful conversation as part of Women's Day series, which we had with Srividya. We learned about different aspects of intellectual property rights and its protection, the infringements, and many more things. We shall continue our conversation as part of the Advantage Learning Bytes Mini Coffee at the Coffee Conversation Show. Please do subscribe to the Coffee Corner Show on YouTube. This episode will be uploaded very soon. Do watch this. It will be very helpful when you are inventing something, your patenting, your trademark, your copyrights, your creative design, so many things you are learning from Srividya. So see, we should connect with another guest speaker who will talk on a different subject. So thank you, Srividya,
Thank you so much.
sharing your knowledge on IPR. We shall continue our conversation. So stay safe. Sayonara, everyone.